Good morning, Alex and friends. I'm Grace. Today is Friday, December 5th, 2025, and you're listening to Alex's News. The high in Riverside today is 69.2 degrees, with a low of 47.7 degrees. So expect a mild day with some chill in the evening. Perfect for bundling up if you're heading out after dark. Coming up, we'll break down the Supreme Court's decision to greenlight Texas's disputed redistricting plan and its implications for voting rights. We'll also examine President Trump's choice to put California agriculture ahead of protections for threatened wildlife, sparking debates on environmental priorities. Plus, other key stories from around the nation and world. All this and more coming up on Alex's News. Stay tuned. Good morning. The Supreme Court just greenlit Texas's new congressional map for 2026. Ethan, walk us through what happened.
Sure, Grace. Yesterday, the court issued an unsigned emergency order letting Texas use its newly redrawn map in the 2026 midterms. The case is Abbott v. League of United Latin American Citizens, docket 25A608, and it reverses a lower court's block. According to NPR and CNN, the 6-3 decision is a significant boost to Republican redistricting efforts and could affect control of the U.S. House.
Why is this such a big deal for House control?
Because the map was drawn to give Republicans more seats in a closely divided House. NBC News reports the Texas plan could flip as many as 5 Democratic-held districts, potentially taking the GOP from 25 to 13 up to about 30 seats. With Republicans holding only a slim majority, that cushion could be decisive next cycle.
How did Texas end up redrawing districts mid-decade?
It's unusual, but Texas Republicans moved in mid-2025 after pressure from the Trump administration. NPR's Hansi-Lo Wang reported that Governor Greg Abbott called a special session following a July 7, 2025 Justice Department letter urging changes to several districts. That letter argued so-called coalition districts, where Black and Latino voters together elect Democrats, were unlawful, citing a Fifth Circuit ruling.
What exactly did that Fifth Circuit decision say?
In August 2024, the Fifth Circuit's en banc ruling in Petway v. Galveston County said Section 2 of the Voting Rights Act doesn't support coalition claims combining different minority groups. Judge Edith Jones wrote the majority, according to NBC News, breaking with decades of precedent like the 1988 Campos decision. Critics blasted the move as, quote, atextual and ahistorical, end quote. Warning, it would weaken VRA protections across the South.
Did Texas say it was just following that ruling?
That was the public defense. State leaders, including Attorney General Ken Paxton, argued they were responding to constitutional concerns in recent case law. But NPR and the Washington Post have noted lawmakers also openly aim to lock in partisan advantage, even nicknaming it the Big Beautiful Map.
What did the new map change on the ground?
It reconfigured several urban and suburban districts where multiracial coalitions had been electing Democrats. Challengers said the lines cracked and packed Black and Latino communities to dilute their influence. MALDEF, LULAC, the Texas NAACP, and Democratic reps. Al Green and Jasmine Crockett all joined lawsuits alleging racial gerrymandering under the 14th Amendment and the VRA.
So what did the lower court find before the Supreme Court stepped in?
On November 18th, a 3-judge federal panel in El Paso blocked the map, ordering the state back to its 2021 lines for 2026. Judge Jeffrey Brown, a Trump appointee, wrote that challengers were likely to prove intentional racial discrimination at trial after a 9-day hearing. He pointed to the DOJ's race-focused letter, public statements by GOP legislators, and surgical map changes that broke apart minority communities, as summarized by NBC News.
Did that panel reject the DOJ's legal theory?
Yes. The court said the DOJ's reliance on Petway was misplaced and that Bartlett v. Strickland doesn't forbid coalition districts outright. CNN noted the panel called the DOJ's July letter improperly racial and unsupported, finding that race, not neutral factors, drove the redrawing. Judge Brown concluded there was substantial evidence of predominant racial intent in multiple districts.
How did the Supreme Court justify overruling that?
The majority emphasized 2 things. timing and deference. SCOTUS blog and CNN report the court leaned on the Purcell principle, saying federal courts shouldn't upend election rules close to key deadlines, like Texas's December 8th candidate filing, just 3 days from today. They also faulted the panel for not honoring the legislature's presumption of good faith absent very strong proof of wrongdoing.
Did they address the partisan versus racial motive?
They did, and the framing matters. The court pointed to Rucho versus Common Cause, which left partisan gerrymandering to the political process, while racial gerrymanders remain unlawful. Justice Alito's concurrence, joined by Justices Thomas and Gorsuch, said the map's impetus was partisan advantage, and because challengers hadn't supplied a viable alternative achieving GOP goals without the same racial effects, the inference favored politics over race, drawing on last year's Alexander versus South Carolina decision.
How did the liberal justices respond?
Justice Kagan dissented, joined by Justices Sotomayor and Jackson. According to NPR and The Guardian, she criticized the majority for a hasty reversal on a cold record, accusing the court of sidelining the trial judges who saw the evidence firsthand. She warned that, quote, many Texas citizens will be placed in electoral districts because of their race, end quote, and argued Purcell didn't apply with the election still nearly a year away.
Remind us how we got from the panel's ruling to this emergency order.
Texas moved quickly after the November 18th injunction. On November 21st, Justice Alito issued a temporary administrative stay that let the new map spring back while the full court considered the request. Yesterday's order made that stay effective through the 2026 elections, barring a different merits ruling later.
What's the political reaction been like?
Sharp and partisan. Paxton called it a massive win for conservatives, while Governor Abbott crowed that Texas is, quote, officially and legally more red, end quote, as reported by NBC News and CNN. Democrats called it a blow to minority voters. DCCC Chair Suzanne DelBene said it decimates voting opportunities, and House Minority Leader Hakeem Jeffries accused the court of approving racial gerrymandering.
How are civil rights groups framing the stakes?
Voting rights advocates say this rewards delay tactics and undermines Section 2 enforcement. Damon Hewitt of the Lawyers Committee told CNN it's a serious blow that renders rights meaningless against raw power. MALDEF's Thomas Sanz warned, as NBC News reported, of guerrilla tactics that run out the clock so courts can't intervene before elections.
Does this tie into a broader national strategy?
It does, and several outlets link it to Trump allies pushing mid-decade redraws after pandemic delays unsettled the usual post-census cycle. CNN says similar fights are playing out in Missouri, Florida, Indiana, and Virginia. California Democrats passed a new map last month that could net them seats, with a GOP challenge scheduled December 15th, and a North Carolina map favoring Republicans survived a court test just last week.
Legally, what precedent is this building on?
We're seeing the court further entrench Purcell for timing and Rucho for justiciability, the Alexander standard, requiring plaintiffs to produce a credible alternative map that meets the state's political aims without racial sorting, raises the bar for challengers. The Brennan Center and Harvard Law Review commentators, cited by SCOTUS blog coverage, warn that an expanded presumption of legislative good faith can shield maps even when racial impacts are stark.
How does the Fifth Circuit's Petway decision interact with this case?
Petway narrowed who can sue under Section 2 by rejecting coalition claims in the Fifth Circuit, which covers Texas, Louisiana, and Mississippi. NBC News emphasized that Petway didn't outlaw coalition districts themselves, but it made them harder to defend in court. The district court in Texas held the DOJ misread Petway, noting Bartlett requires a single minority group majority for certain VRA remedies, but doesn't ban coalitions. The Supreme Court didn't settle that merits dispute here, focusing on timing and presumptions.
What's next procedurally in Texas?
The case still heads to a full trial on the merits in the Western District of Texas, and appeals will follow. But for 2026, the new lines are in place, barring a dramatic and unlikely reversal. Candidate filing closes Monday, December 8th, and the March 3rd primaries are fast approaching, which is precisely why the majority leaned on Purcell, as SCOTUS blog noted.
What could this mean for minority representation long term?
If the map holds through 2026, it could lock in reduced influence for multiracial coalitions in Houston, Dallas-Fort Worth, and elsewhere. The Texas Tribune and AP warn that durable partisan maps with racial effects may become harder to challenge under federal law, especially with Petway limiting coalition claims. Advocates may pivot to state courts or Section 2 single minority claims where possible, but the window is narrowing.
Are we likely to see the Supreme Court revisit coalition districts directly?
There's a live circuit split brewing, and petitions are moving. NBC News says Petway's break with older precedent has drawn national scrutiny, and both the Brennan Center and Democracy Docket expect a Supreme Court showdown over coalition claims. But it may not happen before the 2026 election cycle fully unfolds, which is why yesterday's order has such immediate impact.
How are Republicans talking about broader implications?
They're framing it as a win for states to set rules and for courts to avoid last-minute meddling. Florida's Pam Bondi cheered the decision as a pushback against federal overreach, according to NBC News. GOP leaders also argue, per CNN, that partisan intent isn't illegal and that Democrats are pursuing similar power plays in blue states like California.
And Democrats' national strategy now?
They're scrambling to offset losses in Texas by squeezing gains elsewhere. California's new map could yield several pickups if courts allow it, and Democrats are targeting suburban districts in states with court-ordered fair maps. But as the Washington Post points out, the Texas ruling complicates their path to reclaiming the House if the GOP locks down those additional seats.
Could Congress step in on partisan gerrymandering?
It could, but it hasn't. Rucho essentially said the federal courts won't police partisan gerrymanders, inviting Congress to act. Multiple reform bills have stalled, and with divided government, the Washington Post and PBS note, there's little sign of a near-term fix.
Bottom line for voters in Texas right now?
Expect new lines, new matchups, and some confusion. According to NPR, election officials were bracing for whiplash after the lower court's injunction, and the Supreme Court cited that risk in stepping in. Voters should check registrations and precinct changes, especially in fast-growing metro areas where the lines moved most.
Last thing, Ethan, what should we watch between now and March?
Watch how many incumbents switch districts and where minority-preferred candidates decide to run under the new lines. Keep an eye on the December 8th filing deadline, legal skirmishes over discovery in the trial court, and whether any state law claims surface. And track parallel fights in California and Louisiana, which CNN and NPR say could recalibrate the national balance ahead of 2026.
A lot to watch, and not much time. Ethan, thanks for laying it out.
Thanks, Grace.
California's long-running water fight is back in the headlines this morning. The Trump administration just rolled out a new plan to send more water to Central Valley farms. Chloe is following it for us. Chloe, what exactly changed today?
The Interior Department's Bureau of Reclamation put a new operating blueprint for the federal Central Valley project into effect today, December 5th. It's called Action 5, and it ramps up southbound pumping from the Sacramento-San Joaquin Delta to boost deliveries to farms and some cities. According to ABC News and Yahoo News, the goal is an extra 130,000 to 180,000 acre-feet a year for the federal system, with potential knock-on gains for the state system if California goes along.
And this traces back to an executive order from earlier this year, right?
Yes. President Trump signed Executive Order 14,181 back in January, just after taking office again, and it laid this groundwork. The order framed California's protections for fish, like Delta smelt and Chinook salmon, as, in the president's words, putting fish before people, and it told agencies to revisit pumping rules. Los Angeles Times coverage noted the order's title, Putting People Over Fish, and said it pushed hard for more flexibility to move water south when conditions allow.
How big is the Central Valley project for people who don't follow water closely?
It's massive, and it's been around since 1933. The CVP is a tangle of dams, reservoirs, pumps, and canals that shifts water from wetter northern rivers to the dry Central Valley, irrigating about a third of California's farmland and supporting a roughly $50 billion farm economy. Reclamation estimates it delivers about 7 million acre-feet a year in total, with roughly 5 million going to farms and around 600,000 to municipal and industrial users who serve nearly 1 million households.
And the state system runs alongside it?
Exactly. The State Water Project is California's own, and it serves about 27 million residents, mostly in Southern California via the California Aqueduct and other facilities. The two systems meet and interact in the Delta, which is an estuary and an ecological choke point. That's where endangered fish live and where pumping decisions directly affect habitat, water quality, and fish getting sucked into infrastructure.
What are the specific changes in this new plan that have people fired up?
Reclamation is opening the door to more aggressive delta export operations, which means trying to move more water south when flows and turbidity conditions look favorable. According to coverage in the San Francisco Chronicle, the plan drops the so-called Delta Summer and Fall Habitat Action, which had protected habitat flows in dry seasons, and it removes earlier export reductions tied to California's Healthy Rivers and Landscapes program. It also tweaks Stormflex flood operations and leans on predictive tools to signal when fish are in danger, but environmental groups say those tools are unproven at the scale needed.
So who benefits right away under the allocation changes?
Farm districts south of the Delta are the clear winners. Their contract allocations jump to 40% on average, up from 35% under the prior rules, and Friant Division growers get 100% of their Class 1 supplies. Cities and industries on the CVP side generally hold at 75% of historical use or public health needs, whichever is higher. But the lion's share of the additional water is intended for agriculture, as ABC News summarized.
How different is this from the Biden administration's plan we saw last year?
Very. The Biden plan, finalized in December 2024, reinstated several protections that had been weakened during President Trump's first term. The Washington Post reported it included winter pumping cutbacks in turbid conditions, preserved habitat flows, and required careful cold water management at Shasta to protect salmon. Environmental groups like the Natural Resources Defense Council called that package a modest improvement after a court-battered period of interim operations.
Are there fresh scientific approvals backing this new shift?
That's one of the flashpoints. Reclamation says Action 5 stays within the range analyzed by the 2024 Biological Opinions from NOAA Fisheries and the U.S. Fish and Wildlife Service, and therefore maintains protections for endangered species. But there are no new biological opinions attached to this rollout. State reviewers and independent analyses cited by the Los Angeles Times and the San Francisco Chronicle warn that increased pumping in low-flow years could boost fish mortality by 10 to 20% and worsen water quality in the Delta.
What's Interior's defense for moving ahead anyway?
Interior Secretary Doug Burgum pitched this as a forward-looking approach that balances people, farms, and the environment while strengthening California's water resilience. Andrea Travnicek, the Assistant Secretary overseeing water and science, emphasized real-time assessments and improved modeling to fine-tune when and how much to pump. According to CBS affiliates that carried Associated Press reporting, agency officials argue they can be more flexible without new harm because they can dial back quickly when fish risks spike.
How are farm groups reacting this morning?
They're cheering. Westlands Water District, one of the biggest CVP contractors serving about 600,000 acres, called the plan a lifeline for growers. Allison Febo said, quote, "It will help ensure that our growers have the water they need to support local communities and the nation's food supply, while also protecting California's wildlife," end quote. Yahoo News and ABC News carried her statement, and they highlighted how this could stabilize planting decisions after years of uncertainty.
And California's response on the other side?
The state is livid and framing this as federal overreach. Governor Gavin Newsom's office said the administration is, quote, putting politics over people, catering to big donors instead of doing what's right for Californians, end quote, according to the Los Angeles Times and CBS 42. Carla Nemeth, who runs the Department of Water Resources, warned that if the CVP pumps more, the state system may have to cut back to comply with California's endangered species rules, which could short Southern California cities and farmers, and violate the 1986 Coordinated Operations Agreement.
That agreement is the pact that governs how the state and feds share responsibilities, correct?
Right. The Coordinated Operations Agreement is a nearly 40-year-old framework for how the CVP and SWP move water and balance obligations in the Delta. Nemeth argues this plan shifts burdens to the state by forcing the SWP to shoulder more of the environmental protection side while the CVP pursues higher exports. According to Maven's notebook, state officials say that upsets the basic give and take that has held the system together through wet and dry cycles.
Environmental groups are warning about species impacts. What are we hearing specifically?
Restore the Delta's Barbara Berrigan-Parilla says more exports will degrade water quality, raise temperatures, and drive toxic algae blooms that affect fish, wildlife, and people. She also warned, as the San Francisco Chronicle reported, that higher entrainment could be devastating for Delta smelt and juvenile salmon, potentially turning parts of the estuary into a, quote, fetid, polluted backwater swamp, end quote. The Golden State Salmon Association says salmon runs are already close to being wiped out in some watersheds, and this could push them over the edge.
Have any lawsuits landed yet?
Not as of this afternoon. Politico Pro and the National Agricultural Law Center say no filings have been posted by California's Attorney General or major environmental groups yet, but legal experts expect quick action, and they point to a nearly identical playbook from Trump's first term, when California sued over 2019 and 2020 CVP changes and won injunctions that led to interim rules and the Biden reversal in 2024.
What would those legal claims look like this time?
Likely a familiar trio. First, alleged violations of the Endangered Species Act if the plan's safeguards don't truly prevent jeopardy to listed fish. Second, National Environmental Policy Act arguments that reclamation shortcut a full review by leaning on last year's analysis without new biological opinions. And third, claims that the move undermines the 1986 Federal-State Coordination Agreement, which could ripple through how deliveries are split between farms and cities.
You mentioned Los Angeles earlier. The president has tied water policy to wildfire response in the past. Does this plan actually affect LA?
Not directly, and that's a point several outlets have stressed. The CVP doesn't deliver water to Los Angeles. The city relies on the State Water Project, the Colorado River Aqueduct, the Los Angeles Aqueduct, and local groundwater through the Metropolitan Water District. When the president referenced January wildfire hydrant failures in LA, the Los Angeles Times and water experts explained those outages were driven by surging local demand, a drained tank, maintenance outages, aging pipes, and high winds foiling airdrops, not a lack of Delta pumping by the feds.
If the state refuses to mirror these changes on its own system, what happens?
That's where things get messy. The two projects share the same delta, so if the federal side ramps up exports while the state maintains stricter fish protections, the SWP could have to reduce its own deliveries to stay within state environmental rules. Carla Nemeth warned this would be a burden shift that reduces supplies for Southern California, while Reclamation insists, per ABC News reporting, that their actions stay within the envelope of last year's science and will not force the state's hand.
How much water are we actually talking about, in practical terms?
The federal estimate for Action 5 is an additional 130,000 to 180,000 acre-feet a year, which is enough to supply several 100,000 households or irrigate hundreds of thousands of acres, depending on crop mix and climate. There's also a potential benefit to the State Water Project of 120,000 to 220,000 acre-feet, but that depends on hydrology and whether the state adopts parallel changes. The big caveat, as the San Francisco Chronicle notes, is that drought years are when the ecological risks spike, and those are precisely the years when extra pumping will be most contested.
How are federal officials justifying the removal of some habitat protections in summer and fall?
They say they can protect fish with targeted, real-time measures instead of blanket seasonal rules. Andrea Travnicek emphasized that improved modeling can forecast when fish are near pumps, so operators can adjust quickly rather than restricting for months at a time. Environmental advocates counter, as reported by the Los Angeles Times, that the delta is a complex, multi-stress system and that habitat flows in hot months are what keep temperatures and water quality survivable for species already on the brink.
What's the economic argument the farm side is making?
It centers on food security in rural economies. Growers say stable water supplies determine whether fields are planted or fallowed, and those choices ripple into jobs at packing houses, truck fleets, and local businesses. Westlands and other districts argue, as Yahoo News summarized, that California's Farm Belt feeds the country with fruits, nuts, and vegetables, and that they can do it while using water more efficiently and investing in wildlife measures when supplies are more predictable.
And the environmental and urban water managers counter that the science isn't on the administration side?
That's right. Groups like NRDC and Restore the Delta point to state analyses suggesting higher mortality for delta smelt and salmon, plus increased risk of harmful algal blooms that make drinking water treatment harder and more expensive. The Golden State Salmon Association is urging Governor Newsom to sue immediately, saying protections are already weak, and adding, as covered by the Washington Post, that some salmon populations are one bad year away from collapse.
What should Californians watch for next, given this took effect today?
2 things in the near term. First, whether California files suit next week and asks a federal judge for a temporary restraining order to pause key parts of Action 5 while the case proceeds. Second, how reclamation actually operates in the next few winter storms, because the on-the-ground pumping decisions during high flows will reveal how far they push this new flexibility and how quickly they dial back when turbidity and fish indicators flash red.
Bottom line, what does today's move tell us about water politics in this new term?
It shows the administration is moving quickly to deliver a campaign promise to farmers, even at the risk of reigniting a legal and scientific brawl with California. According to AP reporting carried by ABC and Yahoo, federal officials believe the economy and flexibility arguments will prevail, while the state and environmental groups are betting courts will again demand stronger safeguards. In a water-stressed era, the collision between food production, urban growth, and ecological survival is only getting sharper, and this plan drops us right back into that fight.
Chloe, thanks for breaking that down. We'll keep an eye on the first legal moves and how operations shift with the next storms. Here are some other headlines. A nearly 5-year mystery takes a turn as federal authorities charge Brian J. Cole Jr., a 30-year-old Virginia man, with planting the pipe bombs discovered near the DNC and RNC headquarters the night before the January 6th attack. Investigators say the fuse of the case was lit by a trail of purchases: galvanized pipes and kitchen timers bought with traceable credit cards, and cell phone data that allegedly placed Cole at the scene. Attorney General Pam Bondi announced the arrest, while FBI Director Kash Patel and Deputy Director Dan Bongino credited fresh forensic work and a reinvigorated probe. If convicted, Cole could face up to 20 years in prison, an explosive development in a case that had long been a ticking question mark. In Missouri, an appeals court struck a chord on chords and clauses, ordering a rewrite of the ballot summary for a proposed constitutional amendment to reinstate a near-total abortion ban. The Western District Court of Appeals ruled the original language, drafted by Secretary of State Denny Hoskins, misled voters by not clearly stating it would repeal last year's voter-approved reproductive rights amendment. The court's new summary speaks plainly. The measure would repeal the 2024 voter-approved amendment providing reproductive health care rights and reimpose restrictions, including bans on most abortions and gender transition procedures for minors. The ruling reframes the debate before the 2026 ballot, proof that in politics, wording can be everything, and every word can be a world of difference. On the world stage, the United States and Kenya ink a 5-year, $2.5 billion health pact. America puts in about $1.7 billion. Kenya $850 million, touted as the first of many, America First global health deals. Signed by Secretary of State Marco Rubio and President William Ruto, the agreement channels money government to government, favoring state-run and faith-based providers to tackle HIV, AIDS, and malaria. The plan sidelines the traditional NGO pipeline, with the administration arguing it trims fat and boosts accountability, while critics warn it could cut muscle from long-standing care networks. Kenya's alignment with U.S. priorities, like its security role in Haiti, gets a nod. Others out of step may find themselves out of the funding loop. It's aid with strings, more liar than Lyra. Stateside, the FDA issues a high-risk warning about specific lots of Abbott's Freestyle Libre 3 and Libre 3 Plus glucose sensors after reports linked them to 7 deaths globally and over 700 injuries. The concern: falsely low readings that can prompt dangerously wrong treatment decisions, skipping needed insulin or overcorrecting with carbs. Abbott says roughly 3 million sensors tied to one production line are recalled, 57 injuries reported in the U.S., and the manufacturing issue addressed. For users, it's trust but verify. Check those serial numbers, because when your meter goes low on accuracy, your risk can spike. And in Washington, a D.C. Circuit Appeals panel hits pause on a lower court's order to withdraw National Guard troops from the Capitol by December 11th. The administrative stay keeps more than 2,000 Guard members on duty, while judges review the administration's appeal of a ruling deeming the deployment unlawful. The move follows a November 26th shooting that killed one Guard member and injured another, intensifying a clash over executive authority and local control. For now, the court keeps the Guard on guard, legal lines still being drawn in the streets and in the briefs. That's all we have for now. Today's episode was made by Alexander King with GPT-5, Gemini Pro 3, Gemini Flash 2.5, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.